kita punya discussion last week ya, kita tak habis lagi kan? Kita tak habis lagi character evidence, right? Sampai mana ingat tak? Sampai mana kita stop character evidence? So kalau ikutkan last week, okay, kalau ikutkan last week, kita character evidence, okay. Kita, alright, kita dah discuss pasal, okay, this will be what we had last week. Kita discuss pasal good character evidence, ya, good character evidence. Okay, kita discuss pasal character evidence. Kita dah tengok in civil case, criminal case. Kita dah tengok generally in criminal case. Sorry, in civil case. So we are looking at character evidence in criminal case. Okay. So, okay, kita dah tengok basically character evidence in criminal case. Kita dah discuss good character evidence. Okay. And then we have discussed bad character evidence. Kita baru discuss satu kot ya, satu. Right, the general rule. Okay. Now, last week, right? Okay, when we talk about criminal proceeding, right? So when we talk about criminal trial, yeah, trial. When we talk about character evidence, yeah, character evidence ada dua. So, adakah we talk about good character evidence? Now, good character evidence, what is the proposition of the law? Boleh bawa ke tak good character evidence? Ingat?
Boleh, doktor.
Okay, good character evidence boleh bawa. Kita ada what section? Section 53. Okay, section 53. So section 53 talk about character evidence can be brought in. Good character evidence can be brought in sebab dia mengangkat bahawa orang yang tidak lakukan, orang yang berperangai buruk, berattitude baik, maka mereka tu tidak akan commit the crime. So that will be section 53. Good character evidence is always relevant in criminal proceedings. So that's why kita nampak banyak case-case di mana good character evidence has been tendered. Now, kat mana good character evidence here produced? By the accused person. Remember good character evidence is protecting siapa? Karakter siapa yang kita tengah concern here?
Accused.
Okay, we are talking about the accused punya character. Ya, character accused person. So, bilakah character evidence of the accused person here be brought in the court dalam konteks good character evidence? Macam mana accused person bawa good character evidence dia dekat court?
Defense case.
Sorry? What?
Dalam defense case.
Okay, dalam defense case, mana dalam defense stage, macam mana? Bila accused person, yes, accused person jadi witness. Yes. Right, accused person jadi witness, bagi exam. Ini proses apa dia akan bagi good character evidence? Dalam proses bila dia bagi ni?
Chief exam.
Alright, dalam proses examination in chief. Ya, maksudnya masa dia beri keterangan examination in chief, dia akan beri good character evidence. Ya, you have this example yang berlaku dalam kes Zahid Hamidi. Ya, he give a lot of good character evidence. Ya, defense stage juga dia berlaku. Okay, satu dia bagi keterangan. So satu defense stage, accused person beri keterangan good character. Satu lagi accused person dia panggil defense witnesses to give good character evidence. Ya. Maknanya sama ada dia beri good character evidence atau dipanggil saksi dia beri good character evidence. And you also have this one dalam kes Zahid Hamidi. Betul tak? So semua saksi-saksi yang dia bawa tu semua reflect yang dia adalah good character. Now, ada tak cara lain you nak yang accused boleh ataupun defense boleh bawa good character evidence? How about dekat prosecution stage? Can good character evidence be produced by the by the defense at the prosecution stage?
Boleh dekat cross. Kat cross-examination
Yes.
tu, madam.
Right. So at the prosecution stage boleh juga accused person bawa good character evidence. Masa tu siapa yang you panggil? Masa tu prosecution sedang panggil prosecution witness. Remember dekat prosecution stage, prosecution panggil saksi dia. So defense elicit good character melalui cross examination by defense counsel. Right? Now, how about prosecution witness ni offer good character? Ada impact tak kepada accused person? Dia offer. Maksudnya, prosecution witness ni during examination in chief, dia yang volunteer good character evidence. Adakah dia ada impact secara negatif on the accused?
Tak ada.
Okay? Tak ada ya. You have to understand.
Hmm.
Okay? When you give, sebab ada impact bila you bagi good character evidence. So sekarang ni kita tengok, dia impact dia apabila you minta good character. Ya, so dalam konteks ini, bila prosecution witness dalam examination in chief volunteer good character evidence, accused person will still be protected. Ya, will still be protected. Right? Now, okay, that will be good character evidence. So maksudnya you got to understand bila good character evidence tu defense boleh bawa dekat court. So this will be the situation. The second one will be when we deal with character evidence adalah bad character evidence. Right? Perwatakan yang tak baik, ya, bad character evidence. Now, what is the proposition in law relating to bad character evidence? You ada general rule. General rule bad character evidence is provided for by section 54 subsection 1. Now, 54 subsection 1 cakap apa? Cuba tengok 54 subsection 1. Previous bad character not relevant except in reply. Kalau you baca, in criminal proceeding, the fact that the accused person has a bad character is irrelevant. So 54 subsection 1 provides you with a general rule that bad character evidence is not relevant, not admissible. Get the picture? Now 54 subsection 1 provides you with a general rule at all stage. Maknanya, general rule dalam section 54 subsection 1 diberikan kepada accused person at all stages of trial. Right? All stages of trial. Now, apa benda dia? So, kalau dia ada good character evidence, so dalam section 54 subsection 1, kalau character evidence itu tidak relevant, tidak admissible, it means that this general rule here provide a shield. Yeah, it provide a shield to the accused person against bad character. So, orang tak boleh bawa sebarang kenyataan ataupun evidence yang relate kepada dia punya bad character. Get the picture? So, now, dalam section 54 subsection 1, boleh tak shield tu broken? Tengok 54 subsection 1. Boleh tak shield tu terpecah? You tengok 54 subsection 1, dia perkataan unless evidence has been given that he has a good character. So, dalam section 54 subsection 1, betul, dia protected. General rule dia protected, tetapi ada shield, however the shield is broken, maknanya protection tidak diberi lagi kepada accused person, maka you boleh bawa bad character evidence sekiranya dia beri accused person tender good character evidence. You get the picture?
Yeah.
Right? So good. Tadi kita dah discuss good character evidence kat sini. So maknanya dalam keadaan tertentu shield yang protect accused person tu boleh terpecah, yang can be broken at the prosecution stage. You get that? So bila accused person elicit good character evidence dalam cross examination, maka by virtue of 54 subsection 1 shield will be broken. Get the picture? Yeah? Now, ataupun shield can be broken at the defense stage apabila dia tender evidence of good character. Right? So now, apa implikasi bila shield is broken? Maknanya accused person boleh ditanya berkenaan dengan bad character evidence. That's the idea. Now, look at section 54 subsection 2. 54 subsection 2. Ya, I nak tengok color lain. Mana color? Okay. Okay, look at 54. Kurang dia. Okay. Alright. Look at 54 subsection 2. Apa yang dia jumpa? Can someone read me 54 subsection 2? Sebenarnya kita dah masuk sikit kot, ya? 54 subsection 2, yes?
When an accused person is charged and called as a witness, he shall not be asked of his bad character BCD.
Okay, alright. So kalau kita kat situ, ya, under section 52, you are talking about what stage here? What stage is this? Section 54 subsection 2 cakap
Defense. Defense.
stage. Macam mana you tahu dekat defense stage?
Sebab dia accused person tu called as a witness.
Yeah, accused person called as a witness. So dalam section 54 subsection 2, apabila seorang accused person itu dia beri keterangan di mahkamah, right? Dia tidak boleh ditanya, ya. He shall not be asked with respect to his character, bad character evidence as a general rule. So dalam section 54 subsection 2, at the defense stage, benda tu berlaku dekat defense stage, as the general rule, tak boleh tanya with regards to the bad character evidence, ya. A person charged and called as a witness shall not be asked, ya. Tak boleh ditanya, and if asked shall not required to answer. Dan sekiranya ditanya, tak payah jawab. So that is the proposition 54 subsection 2. Now 54 subsection 2 also provides you with the general rule. Ya, general rule iaitu protection against accused person, tak boleh bawa bad character evidence. So kat sini pun ada shield. Faham? So shield ada dua. Satu shield tu di bawah 54 subsection 1 yang general dekat semua stage. Right? Satu lagi shield dekat defense stage. Ya, defense stage. Right? Tapi shield tu can be broken. It can be broken kalau yang 54 subsection 1 you bawa good character. Shield broken kalau you bawa good character evidence. Now, 54 subsection 2, however, dia bagi situation, ya, instances where shield can be broken. So 54 subsection 2, memang general rule you tak payah nak disclose bad character evidence. Tapi sekiranya dia jatuh dalam A, B dan C, you boleh bawa bad character evidence. So ada 3 situations. Bukan 3, dia ada lebih daripada 3. Ada 3 provisions that allow for bad character evidence to be tendered. So 3 provisions. Iaitu dalam section 54 subsection 2A, 54 subsection 2B, 54 subsection 2C. Get the picture? So sekarang ni maknanya, so okay. So yang penting ialah sekarang ni shield tu broken, ya. The shield can be broken. So if the shield can be broken, dia boleh ditanya berkenaan dengan dia boleh cross or relating to bad character evidence. So that's why bila kita tengok kat sini, so if you look at this situation, kalau shield tu dia pecah dekat the prosecution stage here, cross examination can only happen at the defense stage. So maknanya walaupun shield to break dekat prosecution stage, tetapi prosecution can only take advantage of the break of the shield dekat defense stage. You get the picture? Right? Cuma dekat defense stage. Sebab dekat defense stage dan pada keadaan di mana accused person testify in the court. Kalau accused person decide untuk be silent, boleh tak prosecution tanya pasal bad character evidence? Tak boleh. Right? Atau kalau prosecution decided to give evidence from DOC, unsworn evidence, prosecution pun hilang kebolehan untuk menanya bad character evidence. You get the picture? So, maknanya utilization of the break of the shield can happen only at the defense stage walaupun pecah dekat prosecution. Ya, shield is broken at the prosecution tapi cross examination happens at the defense stage. Maknanya bad character evidence you bawa dekat sini, ya, bad character evidence. Okay? Now, get the picture, faham? So now, let's look at the situation. So, if you have this proposition, so you kata sekarang ni tadi, Okay, section 54, subsection 1, section 54, subsection 2, right, provides you with a general rule that bad character evidence is not relevant, not admissible. Betul, ya? So it's not relevant, not admissible. So what happened here is that an accused person is protected by the law against bad character evidence. So kita nak tengok keadaan ni kan, when can shield be broken? Right, when can shield be broken? Okay, shield can be broken satu dalam exception in section 54 sub 1. So that will be the situation where the shield can be broken. Maknanya dia pecah bila, iaitu bila ni?
Good character.
Yeah,
evidence.
good character evidence is being produced. Kita dah discuss, ya. Okay. Now, that will be one situation where the shield is broken. The second situation where the shield is broken when you fall within section 54 sub 2 sub A. Yeah, 54 sub 2 sub A. Now, what is 54 sub 2 sub A? Nampak macam nombor 8 pula sini. Okay. Now, what is 54 sub 2 sub A? 54 sub 2 sub A, the proof that he has committed or been convicted of other offence is admissible evidence to show that he is guilty of the offence herewith he is then charged. So, dalam section 54 subsection 2 subsection A, you are referring to the prosecution tendering evidence to show that he is guilty of the offence, the previous conviction. So, you're talking about 54 sub 2 sub A ini ialah the previous conviction. The previous conviction relating to offence that are the same. Maksudnya dia jatuh dalam similar facts evidence. You ingat tak similar facts evidence? Evidence 1. You ada modus operandi. Maknanya, kalau a person, katakan a person now is charged for rape. Sekarang ni accused person is charged for rape. 10 tahun dulu he was charged, he has been convicted and charged for sexual assault. Ya, sexual assault. Ni now. Ya, 10 tahun lalu sexual assault. Dia jatuh tak dalam kategori SFE? What do you think?
Tak, Doktor.
Right?
Tak.
Tak. Okay? Tak ke ya? Dia dalam generic yang sama. Okay, kalau yang kat sini, this particular offence, you boleh bawa dia dalam previous conviction, you boleh bawa sebab dia dalam generic yang sama. Offence tu dalam kategori yang sama. Okay? Of course, when we talk about similar facts evidence, you're talking about offence yang sebiji sama. So, basically then, when you talk about previous conviction 54 sub 2 sub W, it has to be previous conviction. Maknanya dia mesti dah dapat convicted. Previous commission tidak sesuai. Kalau you baca 54, kalau you baca section, kalau you baca SFE, dulu SFE you tengok section berapa? SFE section 14 dan 15. Yeah, that is where you study SFE. Now, kalau section SFE, dalam SFE, right? Kalau you tengok explanation to section 14. Ya, baca penerangan dalam section 14, explanation 2. Ya. Explanation to section 14. Ada? Jumpa tak? But whereupon the trial of a person accused of an offence, the previous commission by the accused of an offence is relevant within the meaning of this section, previous conviction can also be a relevant fact. So, kalau you bawa evidence, ya, if you bring evidence under similar facts evidence dia much wider than character evidence. You get the picture? Character evidence, you hanya boleh bawa previous conviction. 54 sub 2 sub A kata, right, shield is broken kalau you boleh buktikan bahawa you are bringing in the previous conviction of the same crime. Tapi kalau you baca SFE, dia jatuh sebagai previous commission. So, previous commission tu tak semestinya conviction. You get that? So, orang tu ada, orang beri keterangan yang dia nampak kawan ni commit a crime. tapi tak ada conviction. It is also relevant under SFE, tapi dia tak boleh relevant as character evidence. You get the picture? Okay? Now, that will be under section 54, subsection 2. Yeah, section 54, subsection 2 talk about the break ataupun the shield is broken by way of you tendering previous conviction of crime. Yeah, cuba tengok you all punya lecture note. Mana dia character? So you have this character evidence. Okay. Right. Okay. This one kita dah discuss tadi, good character. So 54 subsection 2A. The proof that he has committed or been convicted of other offence is admissible evidence to show that he is guilty of the offence. So maknanya he has committed and been convicted. Sebabnya kat sini ialah dia mesti previous conviction dia kena commit that crime. Okay. You look at this case. Right, the person must be charged. Okay, Sterland kata the person must be charged, tak boleh cuma suspect. Then when you look at section 54 subsection 2A, despite whatever is stated here, it has to be previous conviction. So 54 subsection 2 subsection A, previous conviction. Right, so kalau orang tu ada police report banyak buat yang dia commit a crime, tapi tak ada action taken ataupun no conviction, dia tak boleh bawa 54 sub 2 sub A. You got to bring it to show previous conviction. Right, kat sini. Alright, kalau you tengok how it is applied, dia boleh bawa, okay. Under SFE dia cakap kat sini, the prosecutor must seek the court's permission to cross-examine with regards to the accused bad character evidence. So remember this happens at the defense stage. So maknanya katakanlah you have at the defense stage, at the defense stage, accused person ini, okay, dia dah undergo process of examination in chief by the accused counsel. Sekarang ni during cross examination, prosecutor nak bawa dia punya previous conviction. Shield is broken, previous conviction. Dia kena minta dulu dekat court yang Arif boleh tak nak bawa previous conviction dia, by virtue of section 54 sub 2 sub A. You have to understand here ialah dekat defense stage, prosecution bukan bawa evidence dia untuk buktikan case dia. Dia bawa evidence dia untuk rebut. You get that? So that will be it. So maknanya the accused person must the prosecution must seek the approval from the judge, to bring the bad character evidence, that is the previous conviction. So boleh bawa, Right, kat sini this particular case, previous crime must have been proved not allowed if the previous crime has been acquitted or discharged. So maknanya, okay, kalau dia mesti guilty, dia mesti guilty, right, for you to bring in the previous conviction. So get that. So, alright. So that will be the thing. Under 54 subsection 2A. So maknanya if you bring evidence of, if you look at this one, the shield can be broken kalau you nak bawa previous conviction. 54 subsection 2 subsection A. Nanti kat dalam soalan akan reflect this proposition. Get that? Now, the second situation where the shield can be broken will be under section 54 sub 2 sub B. Right, 54 sub 2 sub B. Now, apa yang ada dalam 54 sub 2 sub B? Can someone read me 54 sub 2 sub B? This one is very, very important. 54 sub 2 sub B, dia leceh sikit. Jadi, you kena really understand what is under 54 sub 2 sub B. Boleh? Orang baca seorang?
He has personally or by his advocate asked question of the witnesses for the prosecution with a view to establish his own good character, or has given evidence of his good character, or the nature or conduct of the defense is such as to involve imputation on the character of the prosecutor or the witness for the prosecution.
Okay, so 54 sub 2 sub B adalah satu lagi keadaan di mana shield can be broken. Maknanya shield can be broken meaning that the accused person boleh di cross examine. Right, I pakai space besar sikit, 54 sub 2 sub. Okay, 54 sub 2 sub B. Ya, anda pakai hitam. Okay ni. Now, section 54 sub 2 sub B. When you read this proposition, let's look. Okay, the shield can be broken if A has personally or by his advocate asked question of the witnesses for the prosecution. So number one, you have sama ada accused person ataupun dia punya counsel ask question to the prosecution witnesses. Betul? Right? With a view to establish his good character. So dia tanya prosecution witness to establish good character evidence of the accused person. So itu satu. Ini dekat stage mana? The shield is broken?
Prosecution.
Yeah, the shield is broken at the prosecution stage. Yang ini yang kita dah discuss tadi. Yang ini. Okay, yang ini. This is the situation. You get that? Ini situationnya tadi. Right? So, dia elicit good character evidence from the prosecution witness. That's why, now, kalau prosecution witness yang volunteer, will the shield tadi be broken? Will the shield tadi be broken? Tidak broke. Tidak break ya, tidak break ya, B-R-E-A-K, tidak break, tak pecah. So maknanya you kena elicit evidence from the prosecution. So you kena tanya soalan. Okay, look at the second one. Or has given evidence of his good character. So maknanya yang kedua ialah accused person has given his good character evidence. So section berapa ini? Sorry, ini at what stage? Defense stage. So repetition yang ini dekat sini. You get that? So at the defense stage sama ada accused person yang beri keterangan during examination in chief atau defense witness yang beri keterangan masa examination in chief. Get that? Okay. So this is a situation number 2 where kalau benda tu berlaku, shield is broken at the defense stage, boleh you bawa dia punya bad character evidence. Okay? Lagi the third one, or the nature or conduct of the defense is such as to involve imputation on the character of the prosecution or witnesses for the prosecution. So you have here, you look at here, the nature and conduct of the defense is so as to cast imputation as to the character of the prosecution or the prosecution witness. Now, you rasa benda ni berlaku dekat stage mana? The casting imputation. When you talk about nature and conduct of the defense, you are talking about defense punya strategi. Cara dia strategize dia punya defense, iaitu dia akan cast imputation on the character of the prosecution or prosecution witness. So the nature and conduct of the defense is that to cast imputation on the character of the prosecution witness. So ini berlaku dekat stage mana? Casting imputation.
Prosecution.
Ya, dia akan berlaku at the prosecution stage. This happen at the prosecution stage. Contoh, I bagi kat you contoh, case Bella. Right, you have Bainon tu is charged for abuse, ya, abuse of the child, ya. So maksudnya, okay, you have Bainon here, right, being charged for abuse. The victim is Bella. You got that? Kalau you recall that particular case, you are the prosecution calling prosecution witnesses, betul? Dia panggil staff, ya, dia panggil staff dekat dia panggil staff di kindergarten tersebut. Dia pusat jagaan tersebut. Dan kalau you recall, during cross-examination, macam-macam defense lawyer bagi Bainon ni bagi keterangan, okay, di cross-examine. Ya, ditanya contohnya, I put it to you that you are a liar. I put it to you that you menipu. Ya, I put it to you that you are a liar. I put it to you that this situation never happened. I put it to you that you take this, you jawab macam ini sebab you nak conceal the fact yang you tak buat kerja. So, you are talking about during cross-examination, apa yang defense buat ialah defense cuba tarnish reputation of the prosecution witness. You got that? At the end of the day, kenapa tujuan di cast imputation tu? Apa sebabnya dibuat macam itu? The aim of casting imputation so that the judge shouldn't believe the evidence given by the prosecution witness. So that's the idea. That is the casting imputation. Apa sebab you cast imputation? This is your strategy. Bila you buat defense, you strategize so that at the end of the day, judge tak percaya dengan dia punya testimony. So that is casting imputation. So dalam konteks ini, the shield could have been broken here. You get that? So kita tengok kes Zahid Hamidi yang akal budi, yayasan akal budi. Right? So you have, so accused person Zahid, prosecution witness dipanggil siapa? Star prosecution witness. Dipanggil PA dia kan?
PA.
Ya, PA dia. So dia panggil Zahid punya PA. Masa examination in chief, no problem. PA tu ceritalah apa yang berlaku, all that. Tapi kalau you tengok apa dia strategi prosecution, strategi defense. Defense was actually attacking on the PA's character. You get that? Right? Dia cakap, you ni tak nak dengar cakap. You cakap, you buat apa yang you nak. You cuai. So that is actually during cross-examination, the defense is they strategize so that the court believe that PW here is not credible. Itu strategi dia. So what the prosecution did, what the defense did was actually casting imputation on the character of the prosecution witness or the prosecution defense. Or the prosecution public prosecutor. Contoh, I ambil contoh lain. You may have cases of trafficking drug. So you panggil IO. So you have IO. IO is giving evidence in the court. This is drug cases. Yeah, the defense tanya soalan dekat IO. I put it to you that there was no drug there. Yeah, defense during cross-examination dia cakap, I put it to you that there were no drugs there. I put it to you, it was you who planted the drug. I put it to you that you have been doing this for so many cases. So what did the defense do? The defense is actually casting imputation on the character of the prosecution witness or even the prosecution. Maknanya prosecution ni bawa kes tapi sebenarnya tidak ada evidence. Dia plant evidence. So that is a strategy brought in by the defense. You get the picture? Pernah kena tak macam tu? Anyone pernah kena? Right? So mungkin you tak pernah kena lah kot. Pegawai-pegawai polis kita yang dah tengah sibuk dengan penamaan calon tu, mungkin ada lah kot dia orang yang kena. Yeah? So there can be situations. So that is casting imputation. Now the moment that happened, it may happen at the prosecution stage. Shield is broken at that stage. So shield is broken at that stage. So now it is open for the defense. Okay, it is open for the accused person. Sorry. It is now open for the prosecution to cross-examine the defense at the defense stage relating to his bad character. So that will what happen. So shield the shield is broken at the prosecution stage. Masa sini. Right, at the prosecution stage. Tapi ini good character. So we are talking about bad character evidence. The shield is broken at the prosecution stage. Yeah, casting imputation. Remember, shield broken at the prosecution stage. Right? Tapi peluang untuk dapatkan bad character adalah at the defense stage. You get the picture? You get that? So that will be the situation. Alright? So get the idea. So kalau you perasan Zahid Hamidi punya bicara, right? Of course the shield has been broken at the prosecution stage. That defense stage pun dibawa bad character evidence of the prosecution witness, right? Of course lah dia kena tanya macam-macam relating to dia punya character. Right? Kan Zahid pun kena tanya pasal dia punya character. Right? So macam-macam jugalah dia tanya kalau you recall balik apa yang situation tu. Sampai macam nak rimas si Zahid Hamidi menjawabnya kan. Kan dia kata prosecution ni berbelit cakapnya. I sebenarnya tak nak jawab macam ni tapi I jawab macam ni. Alright? So kalau you all recall lah what transpired during that time. So maknanya dia boleh ditanya berkenaan dia punya bad character evidence. Get the picture? So that will be section 54 subsection 2B. Simple je kan? Okay. Simple je ya. Okay. So tengok kat sini. So 54 subsection 2B. Alright. Tadi saya pecahkan 3. Tadi saya discuss, saya terus pecahkan 3. Satu, you dapatkan prosecution, you elicit good character evidence. Satu lagi, accused person give good character evidence. Satu lagi, casting imputation. Ya. Tapi dalam lecture ni saya pecahkan 2. Ya, iaitu satu, di-establish good character, sama je. Ni good character evidence. Tapi good character evidence ni ada 2 cara. You get that? So it's the same thing dengan I punya lecture. Cuma tadi I jadikan 3, dia jadikan 2. Tapi yang tu ada juga explanation with casting imputation. You get the picture? So if you look at this one. Alright, ini semua yang kita dah discuss tadi. Kalau sekiranya you hanya ditanya pasal benda-benda yang biasa-biasa je, then the shield will not be broken. Right? Tapi kalau the shield will be broken kalau dia tanya soalan yang reflect the character, ya, the casting imputation. This part is actually the one yang a bit complicated, ya. So soalan yang macam mana? So maksudnya bila you cakap pasal casting imputation, you are attacking on the character of the prosecution or prosecution witness, ya. So how do we define casting imputation? By way of literal interpretation or by way of dekat sini, ya. This one, nature of conduct of the defense involve unnecessary and unjustifiable imputation. Maknanya sekiranya you cakap dengan dia, if you ask the person simply, okay, you tanya, okay, you have prosecution witness, this is the prosecution stage. You have prosecution witness. Kalau during cross examination, iaitu oleh defense lawyer, tengok case bela tadi. Right? Defense lawyer cuma tanya, I put it to you that you are lying. Ya? Yeah? Okay? Saya cakap awak ni sebenarnya menipu. Kalau simple sekadar macam tu je tak apa. Right? Tapi it become kalau involve unnecessary, unjustifiable imputation tu yang tak boleh. So maksudnya you over. Bukan sekadar, okay, you menipu ke, tapi you menipu, lepas tu you sebenarnya nak macam-macam lah. You add additional element tu dimasukkan kat situ. So that is amounting to casting imputation. You tengok kat sini, the nature of conduct of the defense will be that sebenarnya defense tu nak cuba cakap dekat court, janganlah percaya this particular person. Unreliable. So that's the idea. Then it may amount to casting imputation. So kalau casting imputation maknanya you boleh cross-examine with regards to the bad character of the accused person. Get the picture? So far get the idea? Itu yang case-case general. Tapi bila kita cakap pasal casting imputation in rape cases. Okay, rape cases juga adalah salah satu situation where they can be casting imputation. Right? Dalam rape cases, it's very important that the victim testify in the court. So, bila dia victim testify in the court, sometimes you akan cross-examine dia, you tanya pasal dia punya maybe sexual preference ke, dia punya sexual habit ke, which may indirectly amount to casting imputation. So, it is something not good. Ya, perception ni lah tak bagus. Ya, maknanya, I put it to you that yang you ni sebenarnya ramai boyfriend. I put it to you yang you memang pantang jumpa sesiapa tu, you boleh bawa dia dekat, you bring him to bed. So maknanya you are casting imputation. Tapi you are talking about offense of rape, what will be the element that you got to prove? You got to prove the element of consent. Right? Maybe by asking the question, you actually cast imputation on the prosecution witness. Get the picture? Tapi sebenarnya dia penting untuk tujuan defense you. Kalau dia penting untuk tujuan defense you, it may not amount to casting imputation. You get that? So you kena tengok fakta case tu ya. Kat sini kata kalau hanya sekadar mere denial, okay, you deny committing a crime, you deny doing that, it is not casting imputation. Tapi it has to be over and above mere denial. Then it amount to casting imputation. Get that? So this will be the situation where the shield is broken. Okay, ada soalan tak dekat sini? Ha? You faham ke tak?
Puan,
Ya.
kalau yang casting imputation ni, for example macam kes Datuk Seri Zahid Hamidi tadi tu, where the defense counsel attack star witness for the prosecution kan. So then how macam mana untuk prosecution tu untuk dia counter balik defense punya tu tadi. Macam mana masa dekat defense stage tu jugalah dia terus dia akan ni lah.
Okay, so sekarang ni kalau you tengok, katakanlah kita ambil kes Zahid Hamidi, yang ambil contoh tu ya. So benda tu berlaku at the prosecution stage. Bila prosecution stage, sekejap give me 1 minute. Sorry. Takut ada beruk ke kat tepi rumah saya. Rumah saya ni sebenarnya dekat tepi bukit. Jadi kan dia banyak, dia macam zoo dah kat tepi tu. Ya, pernah saya bagi lecture tu, dia pergi dekat tingkap saya. Si monyet tu. Okay. Jadi macam dengar-dengar dia ada. Okay. So, now what happened? Dalam kes Zahid Hamidi, prosecution stage, you ada prosecution witness. Right? Okay, dia akan berlaku proses examination in chief. Yang kat sini tak ada masalah lah. Dia beritahu apa yang dia kata, dia rasa benda tu berlaku. Tapi, the defense ni dalam cross examination, defense dah strategize dah. Betul tak? Mesti dia dah discuss. Kita ni, strategi kita nak put the blame on this person. Kita nak kata dia ni, okay sekarang ni bukan Zahid yang salah. Ya? Bukan Zahid yang suruh dia bayar. Because the offense was that you use the money from akal budi to pay the credit cards and whatnot. So that's why it becomes CBT. Yeah? Okay, macam tu. So you are saying that, okay, for that particular crime, kita punya strategi ialah kita nak cakap bahawa prosecution witness ni tak reliable. Prosecution witness ni seorang yang degil, yang buat kerja sendiri, yang tak ikut instruction. So you have strategized within your defense. So what you did was that you cross-examine with regards to his or her character. Dan you, the extent of you punya cross-examination bukan nak tanya, sekadar nak tanya, okay, I put it to you that you did not do this or you do that. Tapi you sampai ke extent yang you kata bahawa memanglah awak grossly cuai. Not simply cuai sikit-sikit, tapi memang degil, tak dengar cakap, okay, langgar arahan, things like that. So that is actually casting imputation. Dan dia strategize untuk prosecution, untuk dia punya defense. Kalau you nampak defense and raise kan was like that kan? Yeah, defense tu dia put the blame to this prosecution witness. So they are doing it for the purpose of defense. Kenapa? Sebab dia nak supaya court jangan believe this particular person bila dia kata bahawa benda-benda tu dia buat atas arahan tapi sebenarnya dia tak sepatutnya atas arahan. That's it. Yeah? So the idea of the defense is actually to convince the court that prosecution witness ni tak boleh dipercayai. Dia akan affect credibility. Now this is a star witness. Kalau court decided that this person shall not be trusted, then you akan tengok, you akan ada evidence dah kurang. So that is the proposition, okay? So apa yang prosecution perlu dapat buat, yang hanya dapat buat bila at the prosecution stage, dia hanya perlu dalam proses re-examination je lah. Ya, masa proses re-examination, dibaikilah apa yang dah tercemar kerana cross-examination. Right? So re-examination. Tapi okay. But remember, at the dalam kes Zahid Hamidi, prosecution stage established ke tak? At the end of the day, totality of the evidence prima facie established ke tak? Akal budi. Prima facie dah ke belum?
Belum. Tak dapat.
Betul.
Tak dapat.
Belum, yang visa tu yang tak dapat prima facie. Yang akal budi ni belum
Ini
lagi.
yayasan. Lagi 47 charge. Ya. So dalam yayasan akal budi, prima facie established. Maknanya, despite apa benda ni, prosecution telah berjaya buktikan ada elemen actus reus mens rea untuk ke semua charge tu. Maknanya betul lah. Okay. Sebab kalau you cakap pasal abuse of power, dia talking about you gunakan duit tu untuk benda lain kan? Kalau you cakap pasal CBT. Ya, duit tu ada duit charity. Ya, duit tu duit charity. Guna untuk kerja-kerja charity yayasan akal budi tapi you guna untuk bayar credit card which is personal. So that is already abuse of power. So that is already CBT. Walaupun at the end of the day, walaupun dia pulang balik duit tu 3 hari lepas tu, you dah commit a particular crime. So that is actually CBT. Yeah, that is one of the charge yang dia ada banyak charge, ada money laundering ke apa ke kan. So that's why kalau tak lekat 1, tak lekat 2, lekat CBT tu pun okey lah. Maksudnya at least lah. Okay. So dalam yayasan akal budi, prima facie has been established. That's why dalam kes itu dia dah masuk dah defense stage. Ya, kalau you follow that ni, dalam defense stage, Zahid dah beri testimony. Dah complete dah. Kalau you tengok dalam kes yayasan akal budi, dia ada banyak saksi yang you nak panggil, tapi cuma baru settle 6 orang. Baru settle 6 orang, dan untuk saksi yang terakhir yang ke-6 ni, prosecution nak impeach. Ya, nak buat impeachment proceeding. Sebab saksi ni beri keterangan yang tak sama dengan keterangan yang diberi dalam MACC. Ya, you ada saksi tu, you ada DW6. DW6 ni beri keterangan dekat mahkamah lain daripada apa yang direkodkan oleh pegawai MACC. Right? So bila keterangan tu direkodkan lain, so sekarangnya prosecution nak impeach this particular case. Dia nak impeach this particular credit, maknanya impeachment proceeding ialah di mana court akan allow for this impeachment proceeding. You dapati bahawa kenyataan yang dibuat dahulu dan direkodkan tak sama dengan kenyataan yang dibuat kat court. Kalau impeachment tu substantial, kalau impeachment tu something yang material, if the process is successful, then what will happen? So kalau percaya impeachment proceeding tu, apa yang diberikan oleh DW kat situ will be expunged from the record. Semua keterangan yang diberi tu keluar, buang. Yang remember ya, keterangan ni dekat defense stage, dia menyokong defense punya case. You get that? So maknanya tolaklah dia. So that's what dia berhenti dekat sini, sebab bila MACC tu nak impeach, dokumen yang dibuat kepada MACC adalah privilege document. It's a privilege document. Dia jatuh dalam section 1, 2, 3. Ya, dia jatuh juga dalam section ni, kita akan belajar section ni. Dia jatuh juga dalam section, sekejap buka ni section dia. 1, 2, 3 iaitu affairs of state. Satu lagi section 1 to 4. Sebab testimony ataupun kenyataan yang dibuat oleh DW6 during interrogation dibuat kepada pegawai MACC. It's an official communication. So it's privilege. Maknanya this particular document is a privilege document. Dan dia pun juga OSA. Sebab tu si Hisham tu sebut cakap, kalau nak bawa this document, you kena declassify dia, jangan jadikan dia OSA. Dia bukan saja privilege document, juga OSA document. So bila you declassify yang kat situ, barulah dia boleh dapat tengok. Sebab kalau tidak, dia akan subject to OSA. Ya, maksudnya dia ialah Official Secret Act. Get the picture, right? So now apa yang berlaku ialah, okay, you dah impeach prosecution witness tadi. Yang siapa namanya PA tu, yes, major ke sarjan ke apa benda kan?
Mazlina ke apa
Ya,
nama?
Mazlina, right? You dah impeach dekat defense stage. Sebenarnya kalau diperasan, kebanyakan daripada saksi-saksi ni memberi keterangan yang juga attack credibility of the saksi. You got that? Right. So, maksudnya you akan kena cross lah apa yang dibuat dekat defense stage. Strategi di prosecution adalah cross examination. Ya, I put it to you yang you menipu kawan tu tak macam tu. That's what kan superior of defense witness ada seorang yang kedua tu yang bos kepada Mazlina tu beri keterangan yang dia ni memang tak boleh dipercayai. Betapalah Zahid ni seorang yang bagus, yang dia memang apa macam-macam dia cakap. So kat situ pun ada bagi banyak good character evidence of Zahid, bad character evidence, casting imputation on the prosecution witness. So you cross je lah. That is the only thing that the prosecution can do. Nanti at the end of the day, court evaluate. Boleh? So that's what happened. Dalam kes ni itulah yang berlaku. So kes ni sekarang tengah stop dekat sini kan. Sambung bulan 1. Bertenang dulu election. Okay, so that will be the thing lah. Right? So
Saya
that
tak
is
follow kes tu yang tak pernah faham.
yang mana?
Kes Zahid ni saya tak follow langsung, tu yang macam agak blur sikit. So ya, itu yang nampaknya lepas ni nak kena study lah baru faham balik.
Sebab bila saya bagi mengajar, saya akan relate kepada kes yang baru supaya supaya you all nampak macam mana it happen, macam mana law to apply dalam kes tersebut. Sebab bagi saya untuk you faham, kalau I ajar you teori dengan PowerPoint je, you all tak faham.
Betul.
Right? So what I will do, I will always bagi example. Example saya, case yang ongoing lah. With expectation yang you all, at least korang-korangnya baca lah case tu. Sebab case baru kan. Dengan
Dengar nak baca
harapan,
doktor. Sebelum ni tak baca sebabnya macam malas kan nak follow.
memanglah macam saya pun sebenarnya muak lah, nak naik muak tengok case dulu, case Najib, case ni kan, naik muak. Nak tengok kan.
Nak tanya, kalau macam kes Najib kan, kita dah boleh bawa lah kan dia punya apa SFE tu yang dia dah rasuah dekat kes SRC, kes MDB tu kita boleh bawa balik lah kan dia punya bad character dia tu. Boleh ke?
Previous conviction lah, you boleh lah bawa. Kalau you nak bawa, you boleh lah bawa. Tapi it's actually macam known kan. Mungkin prosecution kata aku ada banyak lagi evidence aku nak bawa, malah aku nak bawa karakter. Semua orang dah tahu dia punya karakter kan. Right?
Okay.
Sebab case 1MDB tu dia punya on its own pun dah banyak sebenarnya evidence dia. Right? Kan? So that is, ini yang case 1112 yang orang yang tak, kalau maksudnya case orang yang remote ni yang tak berapa banyak lah. Ya, yang that's why kita pakai, kita kena korek dia punya previous conviction. Kalau you klik case Anwar Ibrahim, melambak dia punya case dia dekat dalam Lexis Nexis. Alright, Najib pun akan ada 3-4 case nanti. Tapi dia punya application kecil dia pun banyak kan. Right? So memang saya dah beritahu kat my student, kat undergraduate pun walaupun dia duduk dekat Korea, okay, dia tak duduk dekat Malaysia, dia baca cerita-cerita Korea, tapi tolonglah untuk saya punya subjek, tolonglah baca kes-kes Malaysia. Saya pun tak suka sebenarnya baca. Macam muak kan tengok balik-balik tu je cerita lain. Tapi saya
kena baca lah nampaknya.
At least follow up sikit. Jadi bila saya sebut tu, you all faham.
Faham,
ya?
Betul.
Macam saya bila saya sebut case accomplice, saya cerita pasal kes Rosmah dengan Rizal. Jadi sebab dia sangat, dia punya facts tu sangat reflect kepada that proposition of law. So nanti kita akan discuss nanti kan, you all belajar nanti witnesses after this topic, ada topik witnesses, perlu tak corroboration, saya akan bawa lagi case tu. Right?
Okay.
Sebab that particular
case tu baca doktor, kes Rosmah tu menarik.
Sebenarnya tapi kadang-kadang kita tengok macam benda ni dragging kan, tapi kan bila I tengok benda ni, it's interesting to see how the prosecution, how the defense and even how the accused person behave. Ya, sebab dia semuanya reflect, benda tu ada connotation of law, macam kes Bella kan. So maksudnya I nak bila student tu my undergraduate especially, sebab dia orang tak ada experience, dia orang langsung tak ada experience practice. So I need to bring a lot of examples with them. Kalau tidak, dia orang lagi tak nampak. Korang mungkin lah boleh nampak sebab you all practice. Tapi dia orang memang tak. So, saya akan bawa kes-kes macam ni lah. Ya, kalau ada kes baru keluar yang I boleh pakai, kes Samiha ke apa ke, saya akan pakai juga. Ya. Yeah? Alright. Tapi dia kena relevant lah kepada kita punya discussion. Okay. So, get that? So, that will be... ada soalan lagi tak? 54 sub 2 sub B. So 54 sub 2 sub B, kita kadang bila baca teori ni kita tak nampak. Lepas tu nanti okay, after I finish with these two topic, I dah habis opinion dan karakter, kita akan buat soalan. Alright, kita akan I rasa kalau habis minggu ni, mungkin minggu depan I boleh buat soalan dengan you all. Tapi you all ni ada hutang saya 2 kelas tak tahu bila korang nak ganti. Ataupun you all nak ganti face to face ke? Face to face ke maknanya, tapi masalah face to face ni adalah hujung minggu. Ya, hari Sabtu. Tapi dia dah penuh. So kalau nak datang face to face bila hari Jumaat petang, saya tak tahu. Right, I will be okay je. Tapi korang pula nak datang Jumaat ada kerja ke apa ke, I tak tahulah. You all decide. So because I rasa face to face will be much more effective. Compared to...
Betul-betul penting kot sebabnya bila saya dah baca karakter dengan opinion kan. Lepas tu bila baca balik soalan tutorial doktor tu terus tak faham adik, terus blank.
Kan? That's why I kena...
Saya tak tahu apa-apa.
Yelah, I kena ajar you cara nak jawab. Sebenarnya law tu ada kat situ, cuma you all tak nampak. Sebenarnya, benda tu lah. Benda tu yang kalau korang tak faham, dia orang lagi tak faham, undergraduate. Tapi bila dia diajar tu, dia orang akan nampak lah. Okay? Boleh ya? Alright. Okay. So, kita dah discuss 3 exception to the hearsay rule. 3 exception to bad character evidence. 1 exception dalam 54 subsection 1. 1 54 subsection 2 previous conviction. 1 lagi 54 subsection 2B. Okay, bagi you break 5 minit. Sebelum kita discuss, okay, kita jumpa balik 9.40 boleh? 10 minit lah ya. 9.40 untuk discuss, kita continue dengan yang nombor 3.
Okey, Doktor.
Okay.
Okey, Puan.
Okay? Dah ada dah semua? Alright, dah 9:40, ada about a few minutes more. Kita masuk second slot, kita punya discussion. So we're going to discuss the last situation where the shield can be broken. Kita tengok dalam section 54, right? 54 sub 2 sub C. Ya, 54 sub 2 sub C. Now let's look at 54 sub 2 sub C. Right? He has given, okay, the shield can be broken if the accused has given evidence against any other person charged with the same offense. Right? The accused person has given evidence against any other person charged with the same offense. Apa yang you nampak kat situ?
Dia
Siapa
punya
yang bagi testimony? Accused person bagi
accused
testimony.
Accomplish.
Okay.
terhadap dia punya rakan
Cubahan.
sejenayah.
Okay, rakan sejenayah dia. So what stage will this be?
Defense.
Okay, defense stage. Maknanya shield broken at the defense stage. Okay, dekat situ ada person charged with the same offense. You ada accused and co-accused charged together. Right? So kalau accused, co-accused charged together, right? The other party can give evidence against bad character. A bad character evidence against the accused person. So macam mana keadaan dia? Alright, 54. Right, section 54 sub 2 sub C refer to the situation where you have A1 and A2 accused and co-accused being charged together. Charged together. Right, charged together. Okay. Cuba tengok Najib dengan Arul Kandar. Okay. Najib dengan Arul Kandar, what are they charged for? They are co-accused, right? They are charged together. What was the offense?
Tampering audit report.
Okay, tampering the audit report relating to the 1M DB. So that will be the situation. Tapi dalam kes tu you all kena, of course that particular case still at the prosecution stage. The reality case tu masih di prosecution stage. Walaupun kalau you recall Arul Kandar testify in court kan? So dalam case, that particular case, Arul Kandar telah disuruh untuk beri keterangan at the prosecution stage. Kalau you all baca, tengok newspaper. Sebenarnya this is out of the ordinary. Kalau offence under the penal code atau any other offence, Arul Kandar boleh testify dekat which stage?
Defense.
Defense.
Dia hanya boleh testify dekat defense stage. By right, he shouldn't be giving evidence in support of the prosecution. That's the law. Tetapi dalam konteks the charge relating to 1MDB, the charge was under MACC Act. Dalam MACC Act, kita ada provision special. Tak ingat saya section berapa, section 54 ke apa, yang membolehkan prosecution panggil defense witness atau panggil accused person to give evidence for the prosecution. So MACC Act dia ada special provision. So this particular special provision was utilized and allowed by the court dalam kes ini. Maksudnya dalam kes biasa benda ni tidak berlaku. Okay, get the picture? So ini dalam MACC sahaja sebab ada provision dalam MACC Act. Get that?
Okay.
Okay. Katakanlah untuk tujuan explanation, saya punya example. Katakanlah dalam kes itu, there was a conviction. Prima facie has been established. Katakanlah dalam kes ini, saya padam yang ini sebab saya tak nak you all confused. Katakanlah dalam kes ini, Arul Kandar dengan Najib at the prosecution stage was convicted. So maknanya convicted dekat prosecution stage. Katakanlah dia ikut proses biasa. Ya, katakan dia ikut proses biasa. So, sekejap. Okay, katakanlah dalam kes ni dia ikut proses biasa. Right? Okay, prosecution stage. Prima facie established. Then, you go to the defense stage. Betul?
Yeah.
Now, at the defense stage, sebab you ada dua accused person iaitu A1 and A2, both of them can testify in the court to support their own case. They are represented by different lawyers. Now dalam konteks ni A1 dan A2 sebaiknya tidak mempunyai lawyer yang sama. Sebab apa dia tak punya lawyer sama? Sebab takut ada conflict of interest. Right, lawyer ni I nak protect Najib ke I nak protect Arul Kanda. So that's why kalau you ada accused and co-accused, the best to prevent conflict of interest is that both are represented by different lawyers. Now at the defense stage, A1 boleh testify for his own case, A2 boleh testify in his own case. A1 akan di cross examine oleh akan lalui proses examination in chief by dia punya lawyer, right? Cross examination by the public prosecutor as well as A2 counsel. Faham?
Okay, faham.
Dan re-examination by dia punya lawyer.
Lawyer.
Ya, A2 pun akan proses sama, cross examination in chief by dia punya lawyer. Ya, cross examination by public prosecutor as well as A1 counsel.
Okay.
Okay, dan re-examination by the punya lawyer. Right, this will be what transpired. Katakanlah while A was testifying in the court, dia beri keterangan relating to A2's bad character evidence. So dia beri keterangan dekat court untuk support dia punya case. Dia kata, okay, sebenarnya saya ikut arahan. Katakanlah A1 is, katakanlah A1 is Arul. Arul testify in the court the fact that sebenarnya saya tak buat benda ni. Sebenarnya memang Najib yang suruh. Dan Najib ni seorang yang sangat mean. Kalau kita tak buat macam ni, dia akan buat macam ni. So you are attacking on A2's bad character evidence. You get that? So now, apa yang berlaku? A1 can be cross-examined by A2's counsel with regards to A1's bad character. So itu yang berlaku. So maknanya A2 masa cross-examination, dia boleh terus attack on A1's bad character evidence in court. Dan this is allowed by section 54 sub 2 sub C. You get that?
Okay.
Alright? Yeah, sebab what happened was that, now bila kita tengok keadaan macam gini, so, jangan tak nampak ya nama-nama dia ya. Ini A2. Ya. So ini adalah A2. Right? Ini adalah A1. Nombor A1 dengan nombor 2 pun lebih kurang sama ya. Okay, this is A1. Right, this is A1. So A1.
Letak nama ke baru nampak.
Okay. Letak nama lah ya. Nampak kan nanti puan kita kes ni tak selesai lagi ni puan, res judikata. Bincang dekat kelas ya. Tujuan I tak masukkan dekat dalam newspaper, kita dibincang kat kelas je ya. So katakanlah ini adalah A1 adalah Arul, A2 adalah Najib. Ya. So what happened was that during examination in chief by Arul's counsel, dia beri evidence of A2 of Najib's bad character. Dia berilah cakap, ya. So Najib ni seorang yang memang dia memang pelik sikit apa macam-macam lah dia kata. Okay, now during cross examination of ni Najib's counsel, dan dia boleh tanya pasal Arul Kanda punya bad character evidence. It is allowed by section 54 subsection 2 subsection C. Get the picture?
Yes.
Now, perlu tak Najib punya lawyer ni minta kebenaran dekat court? Ya Arif, I wish to cross-examine Arul Kanda with regard to his bad character. Perlu tak? Tak perlu. Dalam konteks accused person and co-accused person, the co-accused person will get an automatic right to cross-examine with regards to bad character. Sebab dia kena charge kan? So the law says that it has to be automatic right to cross-examine. Tak perlu minta kebenaran. Tadi you kena minta kebenaran. Boleh tak I nak minta kebenaran untuk bawa dia punya previous conviction, prosecution? Kalau 54 sub 2 sub A. Dalam of sub 2 sub B. Dalam kes ini you tak payah minta kebenaran. Automatic court kena bagi. Get that? Now, so Bila masa keadaan itu, the elements that you got to prove under here will be the accused person here, maknanya Arul here is giving evidence against. Is giving evidence against the co-accused. Ini elemen yang dia kena buktikan. Maknanya, for section 54 sub 2 sub C shield to be broken, Arul Kanda mesti memberi keterangan against Najib. Ya, giving evidence against. So, giving evidence against tu maksudnya apa? Right? According to the case of Murdoch and Taylor. Ya, according to this particular case, evidence against bermaksud bahawa Arul Kanda is giving evidence to support defense case. Dia beri keterangan untuk support case dia, or dia beri keterangan which undermine to support the prosecution's case. To support prosecution's case. Or to undermine the defense case. Maknanya Arul Kanda bila dia beri keterangan, dia support prosecution. Masa dia beri keterangan pasal bad character of the accused person, memang saya bersetuju dengan prosecution, memanglah dia seorang yang menggunakan kuasanya dengan sewenang-wenangnya. Okay, you are talking about character evidence tapi support prosecution case. Then automatic 54 sub 2 sub C will be broken. Ya, shield under 54, shield will be broken, 54 sub 2 sub C, you boleh cross-examine. Atau, ya sama ada dia support prosecution stage, atau dia undermine defense stage. Ya, dia undermine defense stage, right? So, maknanya, the undermine defense stage, maknanya dia merosakkan defense punya, undermine the defense of the co-accused, undermine the defense of the co-accused, bukan undermine the defense stage, undermine the defense of the co-accused. Ya, undermine the defense of the co-accused. Okay, dia cuba nak jatuhkan defense of the co-accused. Sepatutnya bila dia beri keterangan, dia kena support case dia. You get the picture? So he should give evidence to say that he's not guilty. Ataupun bukanlah sesuatu gitu. He should be giving evidence to show that he is not involved in actus reus and mens rea. Dia kena support case dia, bukan dia pergi condemn orang punya case. Tapi dalam apa yang berlaku ialah dah dia punya keterangan support prosecution, lepas tu dia pergi condemn kan defense the other party punya defense. Get the picture? So that is what it meant. So kalaulah defense dia hanya sekadar untuk advance dia punya defense, hanya sekadar untuk diri dia punya case, then it's not evidence against the co-accused. So dia beri keterangan untuk beri untuk beri sokongan. Saya hanya menerima arahan. Arahan tu ada dekat dalam minit ni. Saya basically did not do any, have no further authority. Okay, macam-macam tu lah. Maksud kalau dia hanya sekadar reflect kepada dia nak bawa kes dia tak ada mens rea ataupun dia tak ada actus reus, then it's okay. Dia tak boleh, maknanya dia tak boleh cross examine. Get the picture? Boleh ya? Right.
Okay.
So how will the court decide? Ini ada kat dalam lecture notes tu lah ya semua. How will the court decide? Court decide based on the court has to decide as a whole. Maknanya secara keseluruhannya you ada banyak common law case tu. Right? Evidence which undermine the co-accused defense. Maksudnya menyebabkan acquittal tu makin kurang lah bagi pihak Najib. So that's how it goes. Okay? So that will be section 54 subsection 2C. Get the picture? Kalau benda tu berlaku, then automatic boleh cross examine. Alright, that will be 54 sub 2 sub C. Ada so far get the picture? Keadaan di mana shield can be broken. Boleh? Alright.
Boleh datang.
Ya, ada soalan tak di sini? Ya, before ada ya.
Let's say lah kalau kata yang accused A1, A2 ni represent by the same defense counsel, ada tak jadi macam tu? Then how? Dia nak cross apa semua tu.
Okay, that's why bila A1 and A2 dia ada defended by the same counsel, dekat situ dia akan ada conflict of interest. So maknanya especially kalau A1 dan A2 dia tidak bukan authority mereka tak sama. Maknanya dia punya the degree of involvement in the commission of the crime is not the same. Satu adalah mastermind dia, satu hanyalah follower. Yang itu akan susah. Sebab you nak tolong siapa? Right? Eventually A1 akan kata I buat benda ni sebab itu. You tak boleh nak bawa argument tu. Kalau they are involved in the commission of the crime together equally, then it's fine. You are involved in this one equally. Maknanya you tak nak salahkan kawan you. Right? Then you may be represented by the same counsel. Sebab it's collective. Tapi kalau ada orang ada superior ataupun more power ataupun likely that kita buat atas arahan, you tak boleh ada sama counsel. Tak boleh. It's going to be conflict of interest. Get that? Remember tapi counsel tu kalau dia appointed pun dia kena consent. A1 dan A2 appoint dia dan dia consent. By right, kalau dia rasa macam benda ni tak boleh nak pergi serentak sama, dia kena reject seorang. So ini you're talking about legal profession.
Sebab saya teringat yang kes cadet UPNM tu kan yang bunuh tu, yang ramai-ramai ragging tu kan. Sebab saya ingat ada accused yang share the same defense counsel tu kan.
Ya,
itu
boleh.
yang tu, betul.
Ya. Sebab kalau commission of the crime dia commit the crime tu degree dia sama, tak ada yang superior, that's fine, boleh lah. Tapi kalau ada orang yang at the end of the day satu tu buat, yang satu lagi tak buat, satu tu mengikut arahan, yang kat situ akan ada conflict of interest. Okay? Boleh. Ada lagi soalan situ? Now, when you look at when we discuss about character evidence, you kena faham when we talk about character evidence tu dia protect siapa? And the Evidence Act dia protect siapa?
Accused.
Okay, dia protect accused person. Right, dia protect accused person. So, what happened to the witness? Right? Siapa yang protect witness? Right? So maknanya kalau you injure the character of the witness, boleh ke tak? Boleh tak? So that is the thing, yeah. So as a general rule, that's why character evidence you protect accused person. Tapi ada tak soalan yang you boleh tanya, you tak boleh tanya this particular person, yeah. Now bila you talk about witness, right? Of course witnesses tu dia tidak protected, character dia tidak protected by the law. So kita nak tengok soalan yang macam mana? Okay, apakah law yang govern proses cross examination? Yang itu kita nak tengok section 146. Ya, section 146. Let's look at section 146. Now if you look at section 146, now section 146 here apply to semua saksi. Tak kira lah saksi tu adalah witness ke, witness tu sama ada prosecution witness ke, defense witness ke, right? Accused person ke. So tak kira lah siapa-siapa yang beri keterangan dekat mahkamah. Okay, ini yang boleh berlaku dalam cross examination. Okay. Now let's look at section 146. Of course, remember, cross examination can only be done by the person opposite to you. So kalau prosecution witness, defense akan cross examine. Kalau defense witness, prosecution akan cross examine. Kalau accused person sebagai witness, then the prosecution akan cross examine ataupun dia punya co-accused lawyer akan cross examine. Now when you look at 146, it talk about questions lawful in cross examination. Apakah soalan-soalan yang dibenarkan untuk ditanya dalam cross examination? When a witness may be cross-examined, he may, in addition to the questions herein before referred to, be asked any question which tend. Dalam section 146, dia boleh ditanya pasal 1A, to test his accuracy, veracity and credibility. So you boleh tanya soalan kat dia untuk determine dia punya accuracy, veracity and credibility. This one will be in general. Maknanya prosecution witness tu dah beri keterangan. Okay, you have for example A kill B. Okay, C nampak kejadian bunuh tu pukul 12 malam. Kejadian bunuh tu berlaku dekat seksyen 7 Shah Alam dekat MACD. MACD dekat seksyen 7 Shah Alam. Katalah C ni adalah pekerja MACD yang tengah baru nak buang sampah. Ya, dia tengah buat cleaning. Lepas tu dia nampak A step B dekat bawah street light. Ya, kat bawah cahaya lampu jalan yang kira-kira 10 meter daripada dia punya location. You get that? So, you can imagine C kena identify A as a person who step. Betul tak? C must make sure that he identify A to be the person who step. So, what happened here is that C akan during examination in chief give evidence relating to the identification. Boleh? Faham? Evidence 1. Right? Dia akan tanya apa? Okay, kenapa? C, can you explain to the court why you think that you saw, the person that you saw was A? Okay? Can you identify A in the court? Dia pun tunjuklah A kat situ. Boleh tak you explain dekat court kenapa you kata itu A? Okay, dia pun cakap lah. Ya? Bila you belajar, dulu you belajar apa? Apakah yang you rely on to determine the quality of evidence of C? Kalau korang ingat lagi lah. Long time ago. Section 9, identification, quality, visual. Anyone?
Sorry, beg your pardon, Doktor.
Okay. C bagi keterangan kat mahkamah.
Okay.
A, court kena determine quality identification made by C is good. Right? You pakai apa? Apa case law yang, apa law yang you kena employ?
Tombol ke ada satu lagi tu? Kalau quality...
Turnbull guideline.
Tombol guideline.
Okay. Bukan tombol, Turnbull.
Turnbull, sorry.
Okay. Okay. Turnbull guideline. Maknanya C akan testify in the court untuk menyatakan bahawa dia memang nampak A step B, correct? So dia akan beri keterangan, yes, I saw it was A. Boleh tak you identify A dekat court? Okay, dia tunjuk A dekat court. Lepas tu dia akan beri keterangan relating to kenapa dia kata itu A, betul? Dia kata dekat bawah cahaya lampu, ya, kedudukannya 10 meter je. Waktu itu saya tengah buang sampah. Lepas tu saya panggil nama dia, dipandang muka saya pandang muka dia. Lebih kurang 10 saat kita saling pandang memandang, maka saya nampaklah dia. Alright, quality identification. Macam tu. So sekarang ni, defense lawyer akan kena cross, betul tak? Defense lawyer akan kena cross to determine whether betul ke yang you nampak tu A, tepat ke, credible ke you punya testimony. So dia akan tanya, dia akan further ask, I put it to you that you did not actually see A. I put it to you masa tu walaupun ada cahaya lampu tapi cahaya lampu tu tak berapa jelas. I put it to you that the distance is not okay. You want to determine the veracity, ketepatan testimony you. So you boleh cross examine on that point. That is what it meant by 54.146 sub A. You get that? So you can cross examine to further determine the accuracy of you punya testimony. Boleh? Boleh tak? Will that be okay? Right? Itu ada dalam lecture note tu ada ya. Maksudnya maknanya tak kira lah witness ke, ya, sama ada saksi ke, accused person ke, you boleh cross examine untuk tujuan itu. Secondly, section 146, you cross examine apa? To discover who he is and what is his position in life. Ya, to discover who is he and his position in life. Contoh. Right? The prosecution panggil, ya, you have prosecution witness who is an expert. Memberi keterangan pakar. Alright. Okay, katakanlah subject matter kepakaran tu ada something yang complicated, something yang susah, tak boleh jumpa. Okay, so you beri keterangan kepakaran. Now, when you talk about an expert testifying in the court, apa yang expert tu perlu buat? Dia kena relate kepakaran dia kan, expertise. Saya adalah biochemist, degree holder daripada University of Malaya. Okey, saya punya degree in chemistry pada sekian-sekian tahun. Alright, saya dah bekerja dekat pejabat kerajaan semenjak tahun 2000. Right, saya dah pergi training, saya dah ini. To determine dia punya position. Dia punya expertise. You get that? Faham? So itu dalam proses examination in chief. Now I cross. Katakan saya cross dia. Saya akan tanya further untuk determine you punya qualification further. Okay, you kata you degree ini, okay, sekarang ni specifically apa yang you biasa buat? Okay, subject matter kita, because subject matter kita mungkin sesuatu yang lain daripada apa yang you punya degree. So I nak clarify further you punya position in life, you punya credibility. That will be in 146 sub B. Got the picture? Nampak tak? So boleh, you boleh tanya, you boleh cross examine. Now 146 sub C is the one that we are dealing with. Kejap, buang benda ni. Okay, 146 sub C. Okay. 146 sub C, let's see. You cross-examine the person to shake his credit by injuring his character. Although the answer to such question may tend directly or indirectly to criminate him, or might expose or tend directly or indirectly to expose him to a penalty or forfeiture. So, subsection 146 subsection 146 subsection 6, you cross-examine here for the purpose of shaking the credibility. You shake the credibility by injuring the character. You hentam karakter dia. You got the picture? You hentam karakter dia. Contoh macam Bella punya case, you injure dia punya credibility by saying that you are lying. You lie. You have always been lying. You never tell the truth. So you injure dia punya karakter. Balik kat section 54, 55 subsection explanation, character refer to reputation and disposition. Maknanya your questioning relate to these two, which is character evidence for the purpose of injuring the credibility. Dia boleh juga dibenarkan dalam section 146. So, if you have PW, Captain Mazlina, ataupun saksi dalam Bella, you injure dia punya credibility by attacking dia punya karakter. Boleh dalam section 146. Get the picture? So, maknanya boleh you tanya soalan. Hentam karakter pun boleh. Tapi, faham? 146 sub C faham? Tapi apa implikasinya? Memanglah implikasinya ialah memanglah kau orang boleh cross examine, tanya benda-benda macam gini, imputing karakter apa tu semua. Implikasinya ialah 54 sub 2 sub B, maybe the shield may be broken. It may amount to casting imputation. You get the picture? Itu implikasi dia. Kalau you tanya pada PW. Right? So maknanya what I'm impressing to you ialah boleh je defense counsel nak tanya soalan pelik-pelik. Injure dia punya karakter. So boleh je. Maksudnya Hamidi tu tanya, okay, lawyer for Zahid Hamidi tu tanya kepada pada Mazlina tu dan injure dia punya karakter. Right? Boleh sebab is allowed under 146 subsection C. Tapi bear in mind the implication will be that the shield could be broken. Get that? Itu. So maksudnya kalau you all jadi saksi, kalau dia orang tanya hentam-hentam tu boleh. Right? Tapi dia akan ada implikasi iaitu 54 sub 2 sub B. So that is the proposition under 146. Okay? So dekat situ I ada bagi you juga case law. Right? So katanya you tengok. Right? So this is it. Alright? Okay. Cross-examination of witnesses boleh je. So this will be an example of the situation where you boleh tanya yang ini untuk observe character accuracy. Yang ini yang saya cakap tadi example character. Yang inilah to shake the credit by injuring the character. So maknanya boleh. Right? So kalau you ada, remember dalam case Rosmah, you ada Rizal. You ada Rizal Mansur. Rizal Mansur ni dia di cross examine Sampai dia pun memang tak malu mengaku bahawa ya, I memang ambil bribe. I memang ambil commission. Ya, Rosmah dapat 1 billion, I dapat sikit je, 50 juta je. Atau I dapat sikit je, 100,000 je. Right? Rizal Mansur mengaku open him, exposing him to penalty of forfeiture. Doesn't matter, boleh ditanya. Dan dia kena jawab. Tapi Rizal perlu nak takut, dia dah counting kan dengan prosecution. Dia dah counting dah memang dah, walaupun dia mengaku dia ambil bribe dengan bangganya, dia tetap takkan dia ambil tindakan. You get that? So because itulah. So that is actually walaupun the answer will be directly or indirectly criminate him is fine. You can still be allowed, you can still cross-examine asking that question. Cuma implikasinya lah tu you kena faham. You get that? Boleh? Will that be okay? That will be 146. Right? Okay, this one the exclusion of evidence. Okay, yang ini yang basically apa yang baru-baru berlaku dalam kes Zahid Hamidi jugalah ya, because they do not want to allow the tendering of witness statement. Ya, the witness statement, the defense witness produce witness statement. So apa yang berlaku ialah prosecution apply untuk buang witness statement tu. Some part of the witness statement tu dia dah expunge daripada rekod. Bila dia expunge daripada rekod, dia tak boleh pakai. Ya, relating to character of PW, ya, character of prosecution witness. So, you dapati you boleh keadaan macam mana. Okay? Alright, tapi tak apa, itu nanti you belajar dekat CTA. So, for the time being, sampai sini je dulu kita punya discussion on character evidence. Boleh? Get that? Ada soalan ke tak?
Doktor nak tanya balik.
Ya.
Okey, tadi kan doktor yang ada bagi contoh yang witness tu yang bila kita boleh yang ada dekat slide yang doktor buat tadi. So implikasi dia akan menyebabkan the shield is broken.
Okay.
Yang ni kan.
Okay. Sekarang ni, this particular saksi, you injure dia punya karakter.
Okay.
Okay, as far as 146 is concerned, boleh, ya?
Okay. So dia akan implikasi dia kepada kes maksudnya witness tu nanti kalau kes dia dekat prosecution lagi.
Okay.
Okay, kes dia dekat prosecution lagi, maksudnya nanti saksi tu punya credibility dekat kes tu dah tak kuat lah kan doktor?
Okay, so apa yang berlaku here, okay, kalau you talk about character evidence, okay, section 146 tadi. So dalam section 146, ya, so you find yang C tadi, so katakanlah you are the prosecution witness at the prosecution stage, right? At the prosecution stage, okay, of course, examination in chief by the public prosecution, masa proses cross-examination, the defense cross-examine dan defense actually gunakan section 146 sub C, dia hentam kawan tu punya karakter, tempat dia ada, okay, dia hentam kawan tu punya karakter, menyatakan bahawa yang attack dia punya karakter, mengatakan dia tidak credible.
Yes.
Right? I put it to you, contohnya I put it to you that you have been lying, therefore you adalah seorang yang tak boleh dipercayai. I put it to you yang ini bukan kali pertama you menipu, you dah banyak-banyak kali menipu sebelum ni dan you lain cakap lain. Maksudnya you are injuring the character to tell the court that you are not credible. Right? You are telling the court that the saksi is not credible. Boleh tak soalan itu ditanya? Jawapannya boleh. 146C kata boleh. Tapi implikasi you ialah this is amounting to casting imputation. Right? It amount to casting imputation dalam section 54 sub 2 sub B. Okay? Contohnya you ada IO. IO ni dia pernah ada kes ya, ada dia dekat dalam kes ya. IO ni pernah ada satu kes. Kes pertama dia pernah didapati implanting evidence. So he planted evidence. It was found in case number 1. Court dah conclude yang dia memang plant evidence. Adakah dia tak boleh jadi IO dalam kes lain? Boleh kan? Dia jadi IO dalam kes lain. Jadi kes 2 yang sekarang ni, dia jadi IO. Tetapi apa yang berlaku masa defense cross-examine dia, defense kata, I put it to you that this is not the drug that is belong to the accused person. I put it to you that you planted the drug. I put it to you that you have been involved in planting drug. Right? You ada seorang pegawai yang tidak mengikut etika collection of evidence. Katakanlah dia cakap macam tu. Adakah this one 146 sub C? Adakah this one 146 sub C?
Ya, doktor.
Okay, setuju ya? Dia adalah the questioning by the defense here basically fall within 146 sub C. You attack dia punya karakter, you kata dia tak credible. So that the court will not going to believe you. So dekat sini, okay, you dibenarkan dalam 146 sub C, tapi will that amounting to casting imputation?
Yes.
That amount to casting imputation. Jadi impactnya, implikasinya ialah shield is broken. So bila shield is broken, defense, prosecution boleh cross-examine accused person with regards to his bad character evidence.
Oh, okay.
So maksudnya shield broken dekat sini, dekat prosecution stage. Dia semua berlaku dekat prosecution stage. Tapi prosecution hanya boleh gunakan advantage itu pada prosecution, so pada defense stage. Masa dia cross-examine defense accused person. Boleh?
Doktor nak tanya, so kalau prosecution nak repair balik yang karakter witness itu waktu re-balik lah kan doktor?
Adalah. Masa re-examination lah.
Okay.
Masa re-examination dia akan repair. Re-examination.
Okay. Alright, faham.
Okay? Boleh?
Boleh.
Ada apa lagi soalan? Will that be okay? Okay. So kalau maksudnya macam gini, kita dah finish with character evidence. So nanti minggu depan mungkin kita boleh cuba buat latihan. I will telegram you all soalan mana kita nak buat untuk minggu depan. So kalau you dapat prepare untuk cuba buat soalan itu, that will be very very good. Sebab nanti kalau first time tengok soalan tu, time tu lah kita nak tengok, time tu lah baru nak buat, korang tak faham soalan. Ya, cuba fahamkan soalan dulu, so during class it will be much better in terms of take home dia. Boleh? Boleh ya? Sebelum election kita settlekan at least buat latihan tu, lepas tu you ada midterm break, kita akan masuk new topic after the midterm break.
Boleh tak?
Jangan lupa you all hutang saja 2 hari. Saya tak kisah kalau korang tak nak buat kelas. I okay je. Ya, tapi you all lah. Right?
Okay,
kalau tak habis.
Kami akan figure out nanti hari apa nak ganti pasti.
Ya, kalau you rasa you nak buat pada hari you all face to face, fine juga. So it's okay. Tapi make sure you all identify the day. Sebab face to face ni, you all hari Sabtu dah penuh. Alright? Hari Ahad agak sukar sikit. Tak tahulah kalau hari Jumaat. Jumaat kalau korang datang UiTM, petang, ambil half day ke, you open travelling time ke, kalau yang jauh-jauh tu Jumaat petang dah travel, datanglah Jumaat awal sikit, I boleh buat kelas Jumaat petang. Pun okey kalau you all nak lah. Tapi you all decide lah. Ya? Tapi kalau itu kalau you all nak face to face. Kalau online tu, you just let me know bila online-nya. Alright? Okay, you all tunggu sekejap biar saya downloadkan you all punya attendance. Ya, hari ni tak ramai sebab sibuk penamaan jalur ni. Okay. I think that will be all for today. Then I'll meet you insyaAllah next week. Okay. So I leave So I leave. Okay, okay kat sini. I leave. Okay, I leave. I tutup meeting kita. Okay, I dah leave. Okay, bye-bye.
Thank you, madam.
Alright.
Selamat bercuti di minggu.
Thank you, madam. Bye.